Well, good evening, and it's nice to be here in Uxbridge at the Senior Center. I've been here a couple times before, and I really enjoy the drive out here and being a little further away. I live in Medfield and have an office in Medway and another in Needham. And I'm here to talk on behalf of the MassBar Association, which sponsors the program. And to the audience here, and then to anybody who might watch this later, we're going to cover a general program of estate planning for elders. And I'd like to start out, if you want to learn more about me, I do have some brochures in the car, which I got distracted and didn't bring in, but I'll make sure people have those. But you can find out more about me basically on our website, that kind of thing. So I'll give you those materials before we wrap up. So I think we should ask if there's anything in particular that you might want to have touched on tonight. And your question ahead of time, ma'am, was around, as part of planning your estate and all of that, particularly about gifting, being, yeah.
Avoiding probate and taxes.
Okay. So gifting of assets, which is a good way to avoid probate, but we'll talk about avoiding probate more generally, and taxes. Okay.
And trust versus wills.
Right. Trusts versus wills. Sounds like a prize fight. Yeah. Any of the other dozen people here or so have a question that you'd like answered tonight? Okay. And we are going to touch on that for sure. All right. So we'll take questions as they come up. So what is elder law? It hasn't always been called elder law. It used to just be part of estate planning, and sort of a specialty came out of estate planning where it looked like there ought to be lawyers who could say, we really know these areas of law especially well that affect seniors generally. So the topics we are covering here tonight are the topics that you find in all elder law discussions. So asset protection planning, asset protection is a fancy word for avoiding spending all your money on a nursing home. Medicare and Medicaid, I won't talk a lot about Medicare. I actually don't know a lot about the Medicare levels of benefit and options and all of that. In approximately 5 more years, I'll have to know more about it. Medicaid, we will touch on a lot there because that touches on whether you have a privately pay or whether you use a government benefit to pay for nursing home care. Long-term care and financial planning, use of long-term care insurance, health care decision-making, estate planning generally, and housing options. So those are the areas I want to touch on. Essential legal documents and planning. So here's some basics on planning your estate that we need to review, probably for some people. Now, a will is the document that legally disposes of your estate when you die. And the will has no validity to do that unless we take it to the probate court, and each county has its own court. So if we take the will to the probate court and file it and pay the fees, and then do what the court tells us, which is publish in the newspaper that the will has been filed and somebody is seeking to be appointed as an executor, and then follow further instructions like provide an inventory of the assets, what was in the estate in other words, to the family, the heirs, and then eventually do an accounting for what we end up doing with all of those assets. Now, if somebody passes away and they've left all of their assets in joint name with a spouse or a child, then there's no need to do a probate of the will, because the will, for example, might say, I give my automobile to my grandson, right? Could say that. But if when I die, my automobile is already in joint name with my spouse, my grandson isn't going to get it, is he? Because the title to the vehicle is what controls. Same thing with your home. You say, I leave my home, this would be my will, right? I leave my home to my daughter. Why? I don't know. Maybe my daughter has been staying with me and helping to take care of me, and I want her to have the house. But if I've already got the title to the house in the name of my son, my daughter isn't going to get it, because my will doesn't matter. What controls is the ownership of that of the house itself. Okay? So how you hold title matters a lot. Same thing with a bank account. I leave all my money to my children in equal shares, but it turns out that I've already put my oldest child down on my bank account to help me out in my old age. Well, unless I made it clear that I was putting his name on my account for convenience, just to help me out, to the bank, it's going to be, well, look, Tim is dead, and now it's supposed to go to the next person that's on the account, my son. Well, he's going to get it. So my will doesn't affect how that comes out. That's all going to be predicted by the title to the asset. The beneficiary on a life insurance policy, same thing. So again, my will might say I give everything to the Uxbridge Senior Center, or whatever, the Friends of the Senior Center, whatever it would be. But my life insurance is already payable to my children in equal shares. My children are still going to get it. So you go down the list of all of your assets and you realize that how you title them and how you name the beneficiary, and they've messed it up because they haven't put the assets just in their name alone so it could go through their will. So anything left in your name alone will go through your will. Anything that's got a beneficiary or a joint owner on it is going to go to that individual instead. So you got to make sure everything is aligned, and that's really what an estate planner has to do, is to look over all of the assets and make sure that they're going to do what you want them to do eventually.
So if your name and, say, your son's name is on a bank account,
Yes.
you're kind of like joint owners at this point, and
Right.
if you die, his name's on it, so he owns it.
Right. Now, some people think that that's really useful. And I like to say, you know, if you're 99 years old and you don't have a long ways to go in this world, then perhaps putting children's names onto accounts is going to work out perfectly. Because maybe you feel like I'm 99, not a lot's going to change between now and the time I go. You know, I might live to be 104, but not a lot's going to change. But, you know, if you're 74 or 84 or even 94 and you want to make sure things go the way they're supposed to, then you either need to write it into a will and have the will control, and the only way the will is going to control, as we've been saying, is to have ownership of everything yourself. So we'll talk about trusts in a minute and how trusts can actually supersede and kind of give you the best of both worlds, the simplicity of naming somebody on an account and the precision that you're looking for to get things to go where you want them to go. Now, wills have to be signed a certain way in order for them to be valid. So in addition, there are popular ways to do wills today, like you can go online and you can do a service like LegalZoom, Rocket Lawyer. There's other ones, and you don't pay a lot of money, but sometimes you're getting what you pay for. I recently went online just to give it a try, and I used I tried Rocket Lawyer. I thought, what a cool name, I'll try that. I experimented, I did a will. Well, the will package on this service only allowed me to put in 6 children. I happen to have more than 6 children, so that was frustrating. So I guess I'm disinheriting the others at that point. I'll be lucky if I can remember the other 2 anyway. So sometimes you get what you pay for there, and they're not necessarily going to be customized to Massachusetts. They may be more generic, these forms. So sometimes there's no substitute for seeing a lawyer to do that. And Uxbridge has some very fine attorneys to go to, so that makes it local and easy. And then there are lawyers that are 25 minutes away, like myself, in Medway. Next item, I would say essential to the plan is a healthcare proxy, because before you die, unless you just happen to go like that, you're going to be sick. And in order to have somebody to make legal medical decisions before you go, you need to name somebody as a proxy. So Massachusetts has allowed us to do that since, I think, 1991. And some of us are old enough to remember the Mary Ann Quinlan case, and then 10 years ago, the Chavo case. And in both of those cases, the person who was not only incapacitated, but I mean just in an outright coma, naturally was unable to make any decisions for herself. And the family members or spouse, the most recent case, Chavo, was the spouse, said, well, I think I know what my wife really wanted to have happen here. She wouldn't want to be kept alive on life support indefinitely. He had an argument with his in-laws over that, and then it ended up going through the federal court system all the way to the U.S. Supreme Court. And the bottom line, the U.S. Supreme Court actually didn't deal with the most interesting issues, in my opinion, but the bottom line was that because there was no health care proxy signed up ahead of time, or other states call it a power of attorney for health care, nothing was done ahead. The only way to get control of the situation is to be a court-appointed guardian. And if that's what you have to do, you have to do it. And, we've done, 1 or 2 in the past 5 years. It's not as common as it used to be because people are using the healthcare proxy law. But it's a much better solution, let's face it, than going to court to be appointed as a guardian for your husband or your child, or for the child to be appointed guardian for their parent. Power of attorney, on the other hand, is anything that's a legal or financial matter. So now we're dealing with, filing the taxes and dealing with the insurance on the house, and there was a tree fall in the house and we have an insurance claim and somebody's got to fill out the paperwork, and you're incapacitated from illness or injury or just old age. The person who has power of attorney for you can do that, can do those things, can sign your name, can sell your house, can deal with anything that comes up of a legal or financial nature. So for that, you need the power of attorney. Now, I mentioned as we started that how you hold title to assets is extremely important, and the deed to the house is among the most important. So in every state, if you own title jointly, it means whoever lives longer wins, owns the house, owns the property. You'll sometimes see husband and wife own title, most of the time in this state, as husband and wife tenants by the entirety. And that just means that, again, whoever lives longer does own the property, and it has some other benefits as well. If, however, let's say mom and dad have died and they've left the house, the commercial building, the farm, whatever it is, to the children in equal shares, they're not going to be joint tenants. They're going to be tenants in common, which is like being partners. And now if one of those children dies, the share doesn't go to their siblings. It goes to the child who died family. So it goes to their descendants, their heirs. They may have left a will, they may not have, but if they have a will, then that share will go down to whoever they've listed. So suppose the child has listed the Hare Krishnas as their favorite charity, and they've left their estate to the Hare Krishnas. Now the other siblings are partners in the ownership of this property with a charity that they don't want to be partners with. If we have inherited property, it's very important that we retitle it, preferably put it into a family limited liability company, or just get it sold before it becomes a lot of trouble to the rest of the family. Real estate deeds, revocable or irrevocable trusts. So a trust, we'll talk a little bit more detail in a minute, is an agreement that you make between you as the grantor or creator of the trust and the trustee, whoever you're going to put down as your trustee. So you can be your own trustee on many trusts, mostly on a revocable trust. And it's called revocable because whatever you put in the trust, you can take back. And anything that you wrote in the trust, you can change your mind and revoke it and go back to some other arrangement that you would prefer. Whereas the irrevocable trust, what you put in the trust, you cannot take back. And the terms of the trust are mostly beyond your control to do anything about from then on. So we'll talk about why would you even do that. It's like, geez, that sounds risky. So we'll get into that. Having a gifting plan. A lot of people do that because, it's not just I give a gift at Christmas and holidays and birthdays, but I've really got a conscious plan about trying to move money out of my name, move assets out of my name, and get it to the next generation. That can be a great idea, but it can also distort the plan by, in some cases, people give more to one than another in the family, and then they don't even it up later. That can create a lot of hard feelings and issues. And the gifting also has its catches. So some people know that there's an annual exclusion from gift tax. So what's the gift tax? We'll talk a little bit more about that later. But the annual exclusion is $15,000 a year. So you can give anybody, for any reason, no strings attached, no tax filing, up to $15,000. Furthermore, you can pay anybody's medical bills or education bills, and there's no limit on those gifts. So that's why when we're paying our kids' tuitions in college and it's costing us $60,000 a year now, that's not considered a taxable gift. So gifting should be part of a plan. And then finally, an asset protection plan that at least recognizes the fact that we're likely to be disabled, we're likely to be incapacitated, we're likely to need help in our very old age, and we should have a plan around how we're going to pay for that and how to protect assets so we don't lose everything in the process. Some companions to the plan. Before you actually get to the point you need somebody that has power of attorney, if you have such a person in your family, I call them a family financial assistant. It's just the person sort of in training who is getting to know your situation. It's a really good idea to have such a person if you can. Some of my clients have had friends and more distant relatives, cousins, and sometimes we even play that role because the client just doesn't have anybody else close by to turn to. Then a family health assistant. Sometimes it's a different person that goes to medical appointments with you and all of that. And an integrated financial plan. So you're planning your estate. Well, what's going to happen when I need help with my affairs and what's going to happen when I die? How does that fit together with my financial plan So I have enough money to last until I die. What kind of investments do I have? How I own those investments, all should be integrated together with the legal estate plan. Having your plan updated, because the law changes rapidly and your circumstances change. It's never said and done. It really has to be looked at. Our rule of thumb is that prior to retirement, every 3 years, if you have a trust plan, every 5 years, if you have a will plan. If you're post-retirement, there's very often good cause to look at it every year because there's enough going on. And that can be just a 20-minute check-in. It doesn't have to be a full-blown pull up the roots and see how the thing's growing situation. Yeah, and the only reason this old car is up there is just because it reminds me that that's sort of how we get at the end. And what was your first indication you really needed an update? Well, things are getting old. Why are you here in terms of staying current? You're here because you want to stay current. I mean, that's you want to see if there's something new you haven't heard. What else should you be doing? You're probably not here. If you have a toothache tonight, you're probably finding a dentist to help you with that because it's very painful. And the reason that's on my outline is that if you are suffering, you probably went to see a lawyer right away and got your situation handled. But in fact, a lot of our situations are not emergencies. They're just planning ahead. For example, why are you updating? Well, I think keeping your plan current is like keeping your medical attention current. Who among us is still taking the same medication today that we were 10 years ago? I mean, things have changed. The types of medications we can use have changed. Legal techniques change as well. Do you not maintain your car? You don't wait till it starts to break down until you get it in the shop. You go for an annual inspection. You change the oil. So the legal plan is really no different from planning almost anything else. Good dental care and good health care. If your will is more than 7 years old, it probably, for one thing, you don't know what it says. For another thing, there may be sufficient things that have changed that it's worth taking a look at it. It was 7 years ago that Massachusetts adopted a new probate code. And so any will that's more than 7 years old right now still uses old terminology. It's not fatal. It'll still do the job, but things have changed a bit. Also, 10 years ago, just think with that period of time, the president was, at that point, Barack Obama. The estate tax code at that time in Massachusetts was still that you could pass up to $1 million to your heirs without any estate tax. The estate tax is like an inheritance tax. It's what the heirs are going to have to pay because you left them some money. And when I first started practicing, that was $60,000. Anything over that could be, or maybe it was $80,000. Now Massachusetts has had it at $1 million for, I think, 12 years. The federal limit today is a whopping $11 million apiece. And if you are married, you're allowed to piggyback your spouse's exemption. So if you're a married couple today can pass $22 million without any estate tax, which affects less than 0.5% of the population. Then the federal estate tax code 10 years ago was only a $2 million exemption. So you can see what's happened just in that period of time. In addition, the Massachusetts law changed in 2003. So anybody who has an estate plan that's that old, which at this point, what's that? It's 15 years. Then I can guarantee that it's out of date with regard to taxes. The probate code changed, as I mentioned, in 2011. The trust code changed in 2012. We didn't have a trust code until 2012 in Massachusetts. The homestead law changed in 2009, and Medicaid is always undergoing change. But one thing I can say, 10 years ago, the exemptions were still very close to what they are today. And we'll talk specifically about those exemptions and the rules in a few minutes. So we've talked about state and federal estate taxes, but let me tell you how those work. So let's say that you pass away and you've got $100,000 in a life insurance policy. Your house is worth, let's say, $400,000. And you had a really good retirement plan, and your retirement plan still has $500,000 in it. So the 400, the 100, and the 500 would make $1 million estate. So based on what I said a second ago, there's no Massachusetts estate tax on that because you have to be over $1 million. So if any one of those assets was a little bit more than $1 million, we start getting into taxes. So if it was only 1.1 million in the estate, the 1.1 million incurs a $38,000 tax. So it doesn't take much if you creep above this number. And so if you have good savings, good investments, if you have a home that's very valuable, it's not that hard today to break the $1 million mark. Suppose you had an estate of $2 million. Massachusetts tax on that will be $99,000. So very close to 100. And that's pretty much how the tax rate will go for the next several million. It's roughly 10%. 10% of anything over $1 million, the $2 million, that's how I came up with the $99,000, $100,000. So roughly a 10% tax. As taxes go, 10% isn't too bad. I mean, if we only paid 10% on our income while we were working, we'd say that's not bad. I like that tax. But tax on your estate, people take offense at that because we figure, well, we've been paying taxes all of our lives, and now I've died, and my heirs are going to have to pay more tax. Where that comes from, by the way, is the fact that unless an asset is sold in your estate, the government doesn't get, otherwise, without an estate tax, doesn't get any tax revenue. So let's say you bought your house for $40,000 and then you sell it for $400,000. You've just made a big profit, $460,000, $360,000. Now, you may or may not pay income tax on that, depends on the exact situation, but suppose that you didn't sell it while you were alive, you left the same house to your children to inherit. Let's make it really easy. Let's say you only have one child. So you leave that house to the child, and the child actually has moved in with you, and all they're going to do is just stay there. You've died, they get the house, and they keep living there. The government, without an estate tax, never gets any revenue from all that built-up profit. If your child sells the house with the facts that I've given you, they may not even pay much capital gains tax on that because the government allows an increase in the tax basis. So you paid 40, the government allows you to increase the tax basis to the value when you died, the date of death value. So that same child says, okay, that's nice, I've inherited the home. Oh yeah, by the way, it's too bad mom died, but anyway, I've inherited the home. And I'm now going to sell it for $400,000. They'll pay zero capital gains tax because they got that step up in the tax basis. So the tax code, both from the income side and the estate tax side, it's very important to play those off each other because sometimes we're actually better off planning ahead that will pay estate taxes only at 10% compared to a capital gains tax at 20% or more. So that's part of what estate planners do, is help families figure out, well, what should we do with that investment property, or what should we do with the second home, or even our primary residence? What's the plan going to be? Now, as to gift taxes, this is where there's a lot of misconceptions. So the only government that we have to deal with in our state that has a gift tax is the federal government. Our state doesn't have any gift tax. In fact, I only know of 2 states that have a gift tax. There may be more. New York has implemented a gift tax, and I believe it's Minnesota. The gift tax, you think about it, it's a pretty ingenious idea on the part of the government back in 1919, I think it was, to say people are getting around the estate tax. They're avoiding the estate tax by giving their assets away while they're alive. So the federal estate tax, then it was called an inheritance tax, was enacted in 1916. And a few years later, they implemented the gift tax to try to catch the people who were just giving it away ahead of time. Now, the gift tax, fast forward to today, is in exact alignment with the federal estate tax. So you as a couple can give away $22 million in your lifetime and not pay any gift tax. And a single person can give away $11 million. So I don't know about you, but I feel a lot better about that. I'm going to go home tonight and just give millions away because I know I'm not going to have to pay any tax on it. That's a great benefit. But seriously, if people who are very wealthy want to give massive amounts away, great. They're not going to pay any tax on it till $22 million as a couple. If you said, well, gee, I've got this undeveloped land out there on the outskirts of Uxbridge, and I want to just give that away. I want to get it out of my estate. I don't need it. My daughter and her husband would like to build a house on it. Fine. I'm going to just give it away. And then you've got this idea in the back of your mind, oh, no, I can't do that because it's worth more than $15,000. And I know there's something about, there's a limit. That limit doesn't affect you in reality until you use up so much of your gift exclusion that you're getting close to the $11 million, and you're nowhere near close to the $11 million, right? Because all you do is give away, birthday presents and holiday gifts, and you're perfectly free. Go ahead, give away that $100,000 piece of land, because you're not going to owe any gift tax on it. You'd have to give away more than $11 million before you start paying gift tax. And like I said earlier, spouses can combine and give up to $22 million. So there are lots of considerations along with that. If you're giving an asset to one child, do you have to build in an offset in your estate plan so that your other children get more of something else? So that's what we often call equalizing. So we have equalizing to do. Other forms of gifting and sometimes lending that we do with our children would include, you helped out this son or daughter while they were unemployed, while this one was ill. You helped this one with college bills. And you look at the ledger, and, if it was a few $1,000s here or there, you might not care. And neither do your kids. But if you start looking at the ledger and, I've given $25,000 more to this one than I have to that one, people have a long memory, don't they, for those kinds of impacts on the estate. And they'll never forget that mom and dad gave more to this one than they did to that one. So you have to address that head on if you're doing any gifting. And you either have to say to the others that don't worry about it, I'm going to equalize this later, or you just have to lay down the law and say it's none of your business. I can give more money to whoever I want to get over it. And I really like the people that say that, because it's like, it's my right to do what I want with my estate. And I can think of a lot of examples where more people should have said that while they had a chance. All right, some other things that we need to be familiar with. That was on the gift tax. Now, what about the Medicaid look back? So a lot of attention gets given to this because people have heard that if they give away assets within 5 years of going to a nursing home, that they may have trouble qualifying for Medicaid, and they're absolutely right. Because Medicaid is not an entitlement. It's not like Social Security or Medicare, which you get whether or not you've been good or bad. But if you've been bad, and you're not really bad, you're just giving away some money. That's not bad. And you've given away assets within 5 years of running out of your money to pay for a nursing home, then Medicaid, that runs Mass Health, or Mass Health that runs the Medicaid program really, will say, oh, we'd love to help you, but tell us everything you did over the past 5 years, and if you gave away anything, that's going to disqualify you. I mean, actually, it literally disqualifies you. I mean, you come back when the 5 years is up. You could have given away 10 grand, and they'd still say come back in 5 years or after the 5 years is up. And there are some other mitigating factors, and you can get the $10,000 back, or you can use another rule that says that you're only disqualified for as long as it takes to spend the $10,000, but it's not quite as easy as I'm describing it there. It really does mess up the plan if you have these kind of gifts. You could give one of your children your 1999 automobile that you're done using, and it's not worth much. That's not going to be on the radar. But if you give away your 2016 recent model car, that's also going to be counted as a gift within the 5 years. So there's this look back period, and there's really no way to sugarcoat that. You have to deal with it. You will see that smaller gifts like the birthdays and the holidays are not counted. And pretty much the rule has been that if you've given away something under $1,000, that Medicaid will not inquire further about where did that $1,000 go. If, however, you gave away $900 every month, then they would pick up on that pattern and say, well, you've given away quite a bit to your children. We're going to disqualify you for the amount that you've given away. Let's talk about the next slide. Okay, so this goes to your question, ma'am, on trusts versus wills. So in general, we like simplicity, and a simple will is just that. It says, I make this my last will and testament. I revoke any previous wills that I've written. I'm married. I have kids. I give my estate to my husband or my wife if she survives me. And if she doesn't survive me, I give it to my kids in equal shares. All of my estate, all of my property. If any of my kids have died, then their share would go to their children. And if they have no children, it'll go to my other kids. Pretty straightforward. I name my oldest two children as executors, now called personal representatives. You can say that pretty much in about 2 pages. If you make the will longer, it's really just to add more provisions about complying with the law, what are the powers that the personal representative has in order to be able to settle the estate. And personal representative is a curious term, isn't it? Because I don't see how you can be personal in any respect with somebody who's just died. But anyway, you're called the personal representative, and you can name alternates. you can name more than one to serve at a time. So if you have 2 children, you could name them both. If you have 3, I suppose you can name all 3. It gets a little awkward if you have more than that. If you happen to have young children, you can name a trustee in the will. So the will says, I give it to my kids provided they're over age 30. If they're under age 30, then it's going to be given to them in trust, and maybe they get 1/4 of their inheritance at 25 and the balance at 30. If I expect the inheritance to be pretty small, like each of my kids is going to get $50,000, I may not make them wait until they're 30. But you get the idea. If the children are truly little, then you can use the will to also name a guardian for the kids. So the will says, I'm married, I've got kids, I give it away. And if anybody is a minor, then I appoint my brother and sister-in-law as the guardians, or whatever you're going to do, right? Okay. So not a lot of people that attend the senior center regularly have minor children, but you might have children who have minor children. And so obviously in my profession, I try to make sure my kids who are having children, that they've got their plan in order. And we have kids with us a lot. And so I am familiar with a law, which is good because I'm a lawyer, that says my child can name me as a temporary guardian, an emergency agent on behalf of them and their children. So I can have permission for up to 60 days to be their guardian for temporary purposes. I may not be a great choice for permanent guardian, my wife and I. We're a good choice for temporary. So I really like that law. That's really handy. And a lot of grandparents should know about that, because you end up taking care of those grandkids sometimes for more than just the afternoon. It could be several days, maybe even longer while your children are on a vacation. Or it could be that they're sick. It could be that I even had a client that was caught in a tsunami. I forget what year that was. Was it 2004 or something like that? They couldn't get back for practically a month. And they needed an emergency guardianship for their kids. So a simple will is attractive to us because everybody knows what a will is. People have been doing them for literally centuries. But they have a lot of imperfections. And some of the issues that are problems become problems when you have just a will have to do with things like second marriages and children from multiple marriages. Leaving assets to someone who is themselves disabled or just less capable. Not very good at handling money, not very good at handling taking care of their own families, this kind of thing. So a simple will where you just say, oh, they're over 30, they get the money, isn't going to help that person out. It might be doing a disservice to just leave them the money. The will doesn't help in minimizing taxes. It's going to invite a longer process because it has to go through court. So there's going to be delays. There's going to be more expense with just having the will. And if we have any concern about our children for the money basically falling into the wrong hands, if I can put it that way, if I had a child that I had any inclination at all, they might be going through a divorce, it probably doesn't make sense to just leave my estate to that child, because then if I die, the child inherits it, but they're going to end up splitting the inheritance with the divorcing spouse. Once in a while, I have a client that says, I like my daughter-in-law better than my son, but usually it's blood wins out.
So then they would use a trust instead of a will?
Right, so then you could use a trust instead of the will, and the trust would say that the child receives the benefit of it, but they don't own it. I call that inheriting control instead of inheriting the assets. Just had a case that I was just called by the divorce attorney saying we were victorious. The court did not touch my client's trust in settling the divorce. And this was a woman whose father had left the inheritance to all of his children in a trust, not knowing who was going to have issues. And it turned out this one daughter, she approached me right after her father died, and she said, well, finally, I've got some money of my own. I can leave my husband, who's been not very nice to me. And I'm worried, though, that I'm going to lose the inheritance in the divorce. And I said, you don't have to worry. As confident as I can be, Massachusetts law protects the trust in a divorce. And like I said, I got confirmation on that yesterday from the divorce lawyer, saying that the other side lost in trying to get any of the trust money. In fact, they didn't even have to work hard to keep it. Basically, the judge said, that's in a trust. No, we're not counting that. So we had lathered the trust with all kinds of provisions to protect the assets, but it turned out we didn't actually need to be that well prepared, you might say. I'm glad we were, because the judge just said, it's a trust. No, husband, you're not going to get it. Now, if there was even more money involved, or there was more at risk, or somebody had a really aggressive lawyer, would they try even harder? Yeah, but we have extreme confidence, very, very high degree of confidence in that approach. So it's not all about divorce. There's what I call the 5 Ds, which include divorce, debt collection, disability of our child or beneficiary, destructive habits, if our child is an overspender, spendthrift, they never knew how to handle money, or they have, unfortunately, alcohol or drug habits, something like that, or they have a spouse who does, or they're near death. Those are my 5 Ds. The trust is a better mechanism, because that agreement that you sign while you're alive between you and your trustee, and you can be the trustee to start, says that we can carry on after you've died to protect the assets for the beneficiaries that follow. Now, can a will create a trust? Yes, it can. A will can make up a trust and create one without having to do the trust while you're alive. But that trust has to be then supervised by the court from then on, because it came through the will. So what this is going to help us see is that there are strong advantages to a trust, and so we'll lay those out. It doesn't mean every case needs a trust, but very often does. So I'm going to take a case study. I'm going to use the Good family. So the Goods, Phil and B, feel good and be good, right? Their first child was Shelby. When she was born, they said, she shall be good, and Shelby stuck. She was. I mean, just look at this kid. Obviously an angelic human being. Shelby grew up and married a guy named Ben Sood. And he's been sued, all right. Shelby was herself very responsible, good-looking, smart kid. But unfortunately, this marriage made her not just Shelby, but Shelby sued, because that's what happened. Her parents died, and her husband's legal troubles and other troubles got her into the position where they were losing the inheritance, because her husband was losing the money in lawsuits. So she lost everything that she had been put in her name, because she inherited through a will, and that meant it came to her personally. And in this case, the simple will for mom and dad was definitely not a good idea. A trust can help. We'll talk a little bit more. A trust set up by another person for you is the best way to go. So if you want to try to protect assets for yourself, there are ways to do that using a trust, but you have to give up all access to the principle of the trust. That's that irrevocable trust I talked about. What you put in, you can't take back. But if mom or dad or your sister or your brother, some third party sets up the trust for you, then you can get access to the money in the trust, the assets in the trust, to live on or to use. Second child, Izzy. Is he good? That's what everybody said. Is he good? It's hard to tell. He's got this smirk on his face. I don't know if we can trust this guy or not. But born with a smirk, and yet, as it turns out, Izzy was a heck of a good guy. And he married a woman named Dee Stable. So she was destabilizing to the home environment. But he was a softie. He loved his wife, took care of her through her disability and all of that. Together they had 3 children. Dee ended up on disability. Again, back to Phil and Be Good, mom and dad died. They left everything to them under the simple will. The inheritance went for Dee's care. If it helped her, great, I suppose. But she was no longer qualified for Medicaid, so she got off of Medicaid. With today's laws requiring health insurance to be purchased, at least in this state, it's hard to avoid being insured, but there are still people that are either not insured at all or are underinsured. There was no money for college education for their kids because they had spent it all on the care situation. And is he broke? Yes, Izzy is broke at this point. 2 more children that Phil and Bea had, fairly good. She married Louis DeMula and fairly inherited again. And what did Lou do? He losed DeMula. So she became fairly broke as well. And then Will Be Good. Will married twice, who, if you hadn't caught on by now, was married twice before. Will inherited. Well, Mary became Mary thrice at that point because she divorced Will. And, of course, Will lost half the inheritance. So is there anything else that can go on with a simple go wrong? Yeah, what else can go wrong is we have probate. We have the hassle of going through the court system and all of that. Can be further complicated by the death of an heir, incapacity, loss of the will, out-of-state property, and then the fees and the delay and so forth there. So extra taxes. So how does a trust help the situation? Basically what you're doing with a trust agreement is you're privatizing the whole process. You're taking it out of public probate, and you're saying, I want this to be done just within the family, privately. I'm going to write up not just a will, but a trust that says, take care of me in my old age, and when I die, divide it up just like my will would say. But I could be much more precise about those arrangements. It's easier to amend the trust. You don't have to have 2 witnesses to sign before. And you can do the extra planning, as I've been talking about, where the inheritance for children is also in trust.
Is this a way to avoid a prenup too?
It is a way to avoid prenup for children. So let's say that I'm concerned, I could die in a car accident tonight, and I've got a child who's going to get married for the second time. I don't, but if I did, and I'm thinking he or she doesn't want to get a prenup, or their next spouse doesn't want to sign a prenup. Prenup, you could, in a prenuptial agreement, if they were willing to sign one, say, hands off any inheritance I get. And of course, wealthy families do that. They basically insist, all right, sonny or daughter, if you're getting married, I want your fiance to sign a prenup because you're going to inherit a lot of money. And yeah, if you can get people to do that. But in some ways, the inheritance trust, as I call it, is even better because it's not subject to a review. Prenuptial agreements, in order to be enforced, have to go through the probate court later, in Massachusetts, they take a second look, and they look and see, is it still fair? On the whole, that's a nice idea. We like laws to be fair. We like situations to come out fair. But it's your money, it's your property, it's your assets that you're leaving to your children. And if you want to make sure it's there for your child and your grandchildren, then you should have the right to control that situation. And the law honors that. The law says, go ahead, write a trust. And when the trust goes down to your children, they can leave it in the trust. They can be their own trustee. That's what the inheritance trust does. So as long as they get a brain in their head, they're qualified to be the trustee. If at the time of your death, they're actually literally then going through either a bankruptcy or a divorce, they definitely shouldn't be the trustee. So we get to look at the situation at the time. And that's what happened with the case I just mentioned a few minutes ago, where I just got the call that she won the divorce. At the moment of her father dying, we realized she was going through a divorce. So we said, you're not going to be the trustee. And we put in actually another lawyer as the trustee. So it was a totally independent party. He basically, the other lawyer, didn't have to do anything. He just had to be the guardian of the money until she was through the divorce. So that worked out very, very well. So good question, Ken, does that work instead of or at least supplement a prenup situation? It absolutely does. It works very well to do that. Now, a trust also creates some tax shelters. So you had asked about taxes, and we've talked about the $1 million and all of that. So Massachusetts allows you to shelter your $1 million exemption so that if you're still married anyway, you can leave your $1 million, if you have that, to your spouse in trust, so that when he or she dies, then your original $1 million is not counted as part of their estate. So the example of that is very simply, let's say that husband and wife have a $1.9 million estate. So they've got a really nice house, a really big IRA, and they've got some nice savings. And $1.9 million isn't what it used to be, but it's still a lot of money in my book. So $1.9 million. If they both die with wills, then that $900,000 is going to result in about $90,000 of taxes for the children to pay. If they use a trust, what they're able to do is protect each of their $1 million exemptions so that when the first spouse dies, we shelter it, and then when the second spouse dies, all that he or she has at that time is basically their half or their portion. So we could totally get rid of the estate tax on the $1.9 million estate in almost every case. So that's a tax shelter if it's drawn up right. Not every trust will do that. You got to have a trust that actually creates the tax shelter. Now, I have a few clients, not very many, that are worth more than the current $22 million exemption. And for all of them, there's a whole slew of other techniques that they'll want to use to help minimize some of the taxes. One of the simplest techniques is actually something many of my clients have done. They've said, I'll give my family everything up to the maximum I can give without tax. Anything above that goes to charity. And there's no estate tax on what you give to charity. So if the exemption for federal purposes is $22 million, I don't know about your kids, but mine are going to be pretty happy getting the first $22 million. I think that ought to do. And then everything after that going to charity, we pay zero taxes to the government. Now, the estate tax code, the federal code, may change again. The current one is set to expire at the end of 2025. So by 2026, 8 years from now, it's supposed to go back to half of that. Well, that's still a lot of money. So instead of 22, it could be 11 plus inflation, so call it $12 million. So there'll be a lot more people paying taxes because there's a lot of people with more than $12 million. But essentially, there a lot of creative ways to protect against the tax, and yet the government will still get taxes on what you can't protect. It's kind of nutty, really, in a way. Every time I talk about this, unless it's your problem, in which case you're all ears. Like, okay, great, yeah, I'm really worth millions and millions. How do I save taxes? Well, then we're going to have a great conversation. But for the rest of us, it's like, really, people have to do that? Yeah. I mean, as long as there's been a tax, there's been tax lawyers trying to avoid you having to pay them. All right, then the trust system also allows for family and professionals to guide the process in the role of a trustee. So you can name family members as a trustee, that's fine. It helps if they're honest. It helps if they're diligent, they pay attention, if they are transparent and they communicate well to the rest of the family. If they're not those people, then you probably should either consider having a financial institution like a Rockland Trust or a Cambridge Trust or a Milford National Bank and Trust Company, one of those kinds of entities be a trustee. Or you can have a law firm be a trustee. It should always be somebody who has a succession plan. In other words, it should be like, don't make your trustee your 90-year-old best friend from college who went on to law school, because he's the same age as you at that point. When is a trust a good idea to look at or get serious about? There's really no set age on that or set of circumstances. My own rule of thumb is that you should do it by the time you're in your early 70s. And the reason I have that rule is that if you look at the statistics in nursing home population, by the time you get to mid-70s, 76, 77, the population in the nursing home just goes up like this. So the people who are in nursing homes, in other words, they tend to be late 70s and older, not surprisingly. The second, so why is that important? Well, if you're planning to try to save some of your assets so that they don't have to get spent on the nursing home, and you have the 5-year look back, then you're going to want to plan at least 5 years ahead of when this could be useful. Now, you may never get a stroke. You may never get Parkinson's or Alzheimer's. You may never need nursing home care aside from a few months of rehab after a surgery. But if you're in that unlucky third of the population that spends a good deal of time in a nursing home, then that's a relevant consideration. Time flies when you're having fun, doesn't it? So we've been at this for just a little over an hour, so why don't we try to wrap it up in the next 10 minutes. Revocable versus irrevocable. So to repeat myself a bit, the trust is an agreement between the trust creator, who's the grantor of the trust, and the trust caretaker, who's the trustee. And it's an agreement to take care of the beneficiaries. Now, you can start out with a revocable trust, which is basically the handshake that you make with yourself or with your spouse. And you say, we have an agreement to use our assets, and here, it's right here in writing in this trust. We agree to take care of each other through our old age. And it starts out by saying you're totally in charge, and anything you want to do with your assets, you're totally free to do. You're not accountable to anybody else. There's no filings with the government. There's no annual fees. You don't have to file separate tax returns. You have a revocable trust. It's just your alter ego. And if you want to take 50 grand out and go to Las Vegas and probably lose it all, then you are free to do that. Because you're in charge, it's revocable. You can do what you want. Now, an irrevocable trust, on the other hand, you got to have a good reason to do this, because now what you put in you can't take out unless you have very unique circumstances. And what you've said in that trust, you're going to have to work a lot harder to find a way to change it. So what do I mean? Let's say that you have the brilliant idea that you want to protect your home so that if you are older and sicker and need nursing home care, it's out of your reach. You can no longer be required to take that out of the trust, sell it, and use the money to pay for the nursing home because you can qualify for Mass Health Medicaid. So that's probably the most common motivation for people to use an irrevocable trust, is to protect the asset. You can also use an irrevocable trust not to protect against the nursing home costs, but you can also use it to protect against lawsuits. You could say, I have a 2-family house down there and I rent it out, and I want to make sure that I'm not personally liable. I've got insurance, but I want to have more protection. An irrevocable trust would be another way to get protection from personal liability. Somebody else says, I want an irrevocable trust because I'm giving my money to charity, but it's going to pay me back money for the rest of my life. That's an irrevocable trust. I want to remove assets from my taxable estate when I die. It still goes to my kids, but I want to take it out of my name. Irrevocable trust. A lot of people do that with life insurance because life insurance is taxable, but if I put it in an irrevocable trust, I've given it up. I don't own it anymore, so the government won't tax it when I die. So there are some really cool purposes for the irrevocable trust. It's powerful, it's useful, but the trustee is not supposed to let go in these circumstances. So if you've put your house in there to protect it, and your son or your daughter or both of them are the trustees, and you go to them one day and you say, you know, I changed my mind. I want to sell the house and go to Florida, and the heck with nursing home planning. I'm just going to spend my money until I run out. They're going to say, well, we're the trustees, Mom. We're not supposed to let you do that. So you probably wouldn't have done this in the first place if you really thought your children weren't going to help you out when you needed them in this case. Most of the time, what the children will answer is, okay, I get it. It's irrevocable, but you are our parents. We love you. This is really your money. You did this to protect it. Now you don't want to protect it anymore. What can we do to help you? So with an irrevocable trust, what you can then have to plan on doing is you can't get the asset out of the trust, but your children can. Or to put it the other way, the trustee can actually make a distribution to the children. So take the same scenario I just mentioned. You own your house, you put it in an irrevocable trust. Now you want the money for some reason that's pent up inside the house. The children, the trustee can deed the house out of the trust to the children. The children can sell the house and give you the money. The trustee, even before deeding the house to the children, could sell the house, turn it into cash, give the cash to the children, and the children can turn around and give you the money. There's nothing illegal about that. In fact, there was a case at the end of 2016 that said specifically that from Massachusetts Supreme Judicial Court. The fact that you put money in a trust and then later it ends up in the kids' hands and they turn around and out of the goodness of their hearts help you out with it doesn't make the trust itself invalid. So where people use this commonly is they say, yeah, I might go to a nursing home. If I go to a nursing home, Medicaid will pay for it. But what if I don't want to go to a nursing home? What if I want to stay home and it costs a lot of money to be cared for at home? How am I going to pay for that? Or I go to independent living for $6,000 or a month. Or I go to assisted living for $8,000 or $9,000 a month. And my monthly income is nowhere near that. How am I going to pay for that? At that time, it's going to be useful to know that this irrevocable trust that you created, we could sell the house, turn it into money, give the money to the kids, and the kids give it back to you to help pay those bills. Now, can we always trust our kids to do that? No. Can we trust maybe one of them for sure, maybe two of them? I hope the heck we have at least one or two. But it's not always about whether we trust them or not. I mean, most people, it's rare that I don't have clients that say, yeah, I trust my kids. That's going to be fine. But we don't know what's going to happen to our kids. So we're only 85 years old and we're in decent health, and we're going to assisted living, and we're going to give our kids money, and for the next 7 years, they're going to keep paying us. Well, what if I put the money in their name and they get sued, or they go through the divorce, or they go through bankruptcy, or they die, and now the money's in their estate? It's a mess. So what's my solution? Maybe you've guessed it by now. Another trust. So we can actually have the children sign another trust, which I call a family health trust. And that trust says the children get money out of the trust only if they're basically using it to help out an extended family member with health matters, hence the name Family Health Trust. So the way it works is they have to front the money. So, at 10 o'clock in the morning, they're writing a check for mom's assisted living, and at 11 o'clock, they're getting reimbursed for that by the trust. So it's a good system. It's worked many times for my clients, and I expect it to continue. Qualification for Mass Health Medicaid is based on having no more than $2,000 as an individual, and as a couple, about $125,000. The community spouse is allowed about $123,000. Anything above that, you're going to have to spend down or find a creative financial way to handle it. If you're younger than about 82, you can get creative financially. You can buy an annuity with the extra money. So you have $300,000 and you're single and you're about to go to a nursing home. We could say the best plan for you and your family is to try to get you on Medicaid to pay for the nursing home, but you have too much money. In fact, you have $298,000 too much. We could take the $2,000 that you're entitled to, that's fine, set that aside. We can prepay for your funeral. We can set up a burial account for $1,500, but there's not much else we can do. The rest of that money we can use, and instead of having money in the bank, we can turn it into income. Now your income will have to be used to pay for your way at the nursing home, but your income is going to be smaller, and it's going to be smaller than what's necessary to pay in the nursing home. And where we're going to get that income? It's because we're going to give it to an insurance company who pays us an immediate annuity. Okay? So what do I have? I have maybe $250,000 in my example to give to the immediate annuity. The insurance company says, oh, you're 82 years old, hypothetically, and your life expectancy is 5 years. So we'll give you back $250,000 over the next 5 years, every month, like clockwork. You're not going to get rich on this. They're not going to pay you a big return. But you'll pay the nursing home, let's say, $5,000 a month, and then Medicaid will pick up the balance. Now, you may go through the entire sum of money, but if you happen to die after a year, you've only paid out $60,000 at $5,000 a month, and the other almost $200,000 is still protected, goes to your family. So if that's important to you, that's the kind of thinking we have to apply to these situations. You got the basic idea. Every situation is different. Analyze it, check it out. That's what elder lawyers will do, is they'll run you through the motions on that. Yeah, question?
What if instead of having assets, you have debts?
You're entitled to pay down the debts, pay off the debts. I mean,
if you're in the red as opposed to having assets or being able to gift or.
you mean and you're planning your estate, like I'm going to die and I'll have all this debt?
Yeah.
Well, the fact is that some people do die with more debt than they have assets, and at that point, your heirs are not liable for your debts. That's the law. In fact, you're not even liable for your husband's or your wife's debts. If they're the ones who ran up the credit card and the credit card is in their name alone and they die, it's their estate that has to pay it. They may not have any estate because they gave it all to you by joint tenancy, beneficiary. There's no estate. I just had a lady who was probably 45. Her husband was 10 years older, 55. He ended up with cancer, and he died. He actually had another ailment at the same time, and they thought that perhaps if the doctors had caught the other ailment, they might have seen the cancer sooner, but they didn't see that. They didn't. Anyway, you get the idea. Anyway, he died. He had a business credit card that he had 30 grand on when he died. He had a personal loan. I'm not even sure how he got this, a loan to put air conditioning in the house, but it was with a bank and it was unsecured, personal loan. He had a few cars with loans, and there was something else that was pretty large. He had about $100,000 in debt. And she said, I'm really worried about this. I'm only 45. I haven't worked for years. I've got 4 kids. What do I do with all this? And I said, well, the first thing you're not going to do is pay any of these credit cards and these loans because they were only in your husband's name. Well, don't I have to pay it? I mean, I got his life insurance. No, you're the beneficiary of the life insurance. The life insurance didn't go to his estate. His estate would be liable. He doesn't have any estate. Everything came to you personally. What about the cars? Call up the loan company, the car loan company, and say, come take the car. Because you don't have to pay it. You can't pay it. So it's interesting that you asked that because that does happen. Yeah. Any other questions? So wrapping it up, countable assets in the mass health situation include everything that's in the bank, revocable trusts, certainly investments, retirement accounts. Now, non-countable assets, the ones that you're allowed to keep and not have to count or sell. Personal belongings, furnishings, 1 automobile, a burial plot, prepaid burial contract, the 1,500 burial account, life insurance policy with a face value up to $1,500, and a primary residence. But the primary residence has to be worth less than $858,000. There are some exceptions with regard to a home. So even if you don't have 5 years to work with, if you've had a child living with you who's been a caretaker for at least 2 years, you're allowed to give the house to that child. That child might be convinced to not keep the house, share it with his siblings or her siblings, but it has to first be deeded to the caretaker child. If you were living with a sibling who was a co-owner of the house, you're allowed to deed it to the sibling. If you have a disabled child, you're allowed to give the trust to the disabled child. So what the state will do is if you are on Medicaid, they will try to collect from your estate after you've died. So they might have said, we're glad to put you on Medicaid, and then a year or 2 or 3 goes by, you die, and when you die, you still have $100,000 left somewhere else in your affairs, in your estate, or on your house. The state will immediately assert their claim to be reimbursed for the Medicaid money. So if you win the lottery before you die, that's going to get taken by the state. If the house was protected for a while because it was your primary residence, but your spouse died, it's no longer going to be a protected asset anymore. They can claim it in your estate and get paid back. So there are some tools there. Long-term care insurance is available to people who are healthy enough and wealthy enough to afford it. There are alternatives to long-term care insurance, which I really like. They involve buying a life insurance policy, but it has a special rider on it that if you end up in a nursing home or need care at home, the additional rider will kick in and you'll get more than just your life insurance amount. You'll get a multiple of that. So an example would be you pay $5,000 a year for 10 years. You've put in 50 grand. If you die, it'll pay your heirs $51,000. That's not very much return on your money, but you're not buying it for that. You're buying it for the fact that it has the long-term care rider. And instead of 50 grand in insurance, it might pay 250 grand of long-term care benefit. That's a pretty good deal. Now, obviously, that changes with your age. So the sooner you do that, preferably before you are in your mid-70s, a lot of those products are not available after even age 72 or 3. But that, at least you feel like you're getting your money back. Whereas long-term care insurance, you pay in, and you may never get your money back because, like house insurance, if you never have a fire, you don't get any benefit from it. I like to say a word sometimes about continuing care retirement communities because that's a pretty popular thing to do. Sell your home and go live in some of these very nice retirement communities. So there are those that you just enter, sign the lease, and you pay your monthly rent, and that's it. It's going to be expensive because they're giving you a lot of benefits. Other retirement communities, you sort of buy in and you put a much bigger down payment. I mean, it can be a few $100,000. You may own the unit, you may not own the unit. Most of the time you don't own it. But because you gave them a big down payment, it keeps your monthly costs lower. So if you have a house to sell and you put it into one of these retirement communities, lump sum payment, a couple $100,000, you might be able to get by with paying a couple grand a month, $2,500 a month. You'll have a nice little, efficiency apartment, and they might also have connected to that community a nursing home if you ever need it. Good to know. If that happens to be you, I do have a checklist, and if you were to email me, I could send you that checklist of considerations before going into such a community. People have questions about reverse mortgages. You own your own home. You'd love to have the money to fix it up, put new windows in, give yourself an extra $500 a month. You could tap into the equity of your home and never make a mortgage payment. It's called a reverse mortgage. So this isn't offered by a lot of banks. There are mortgage companies, however, that do it. And this could be a solution to your cash flow problem while still keeping the house. Nobody pays that loan off until after you die or permanently move out. Or those could be the same thing, right? That's maybe better than a home equity line of credit because you have to pay the home equity line of credit every month. Also, it's a frequent concern these days. We have family members with some special need. Could be a disability, or it could be that they just can't handle money and that kind of thing. So there are a couple of varieties of special needs trusts that you should be aware of. One of them is to take the individual's own money. That is, if they have any extra money, they are allowed to protect that in a separate trust before age 65, known as a special needs trust or a D4A trust. Has to be done before 65 because that's the cutoff. After that, it's considered Medicaid planning. On the other hand, you can do a third-party trust. So if it's you, mom, dad, grandparent, and you want to leave money for the individual that has the disability, you're allowed to do that. And unlike the D4A trust, where you have to name the state as the beneficiary, on a supplemental needs or a third-party trust, it's always there for the family. You don't have to name the state as a beneficiary. So that's a pretty efficient, effective way to handle that. So we talked about gifting. I didn't say much about, quote, avoiding probate by itself, but the way you avoid probate is you make sure that when you die, you don't own anything. And as you can tell, the best way to do that is with a trust. So are there any other questions? Okay. Well, you've been a great audience, all 100 or 200 of you. No, thank you both very much for being here. And I hope in the viewing audience that a few people get something out of this as well. Thank you very much for having me.